Okay, welcome everyone. Good afternoon. I'm Kelly Weiss, the Executive Director of Marketing and Communications at the Law School. We're here for the continuation of our Racial Justice Speaker Series. And before we get started, just wanted to outline a few ground rules. Throughout the presentation, we will be on mute, and Professor Aldana will give her presentation or lecture, and after that we'll have time for Q&A. And when we do start that, you can send your questions directly to me, and I will ask Professor Aldana for her response. So that's how we handle our Q&A. I also want to note that this is being recorded. We will put it onto our Racial Justice Speakers series at our website, so you can find it there. It'll be on YouTube if you'd like to check it out there. And that's usually a couple days to even a week after the event, you'll find it there. Also, speaking of after the event, we are offering NCLE credits for this lecture. You will receive a notice from Robin Fulton. She'll send an email to you with those credits. And please give us some time to get those processed within a week. Look for that email from Robin Fulton. And you can also, if you haven't heard from us in a week, please get in touch and we will help with that. And so I'm going to now hand it over to Dean Johnson.
Thank you. Thank you all for being here today in our latest installment of the Racial Justice Speaker Series. We began this series last fall to talk about systemic racial injustice in the United States after seeing a series of African-American men and women killed by police. Over the course of the year, we've had an opportunity to hear from critical race theory scholars, from public defenders, and from others about their views on systemic injustice in our system of law in the United States, and possible avenues for reform and change. Now, today we're very lucky to have King Hall's own Raquel Aldana. Professor Aldana is a graduate of Harvard Law School. She's been a teacher for a number of years, including at the University of Nevada, Las Vegas, and later McGeorge School of Law. She joined the UC Davis community as the Associate Vice Chancellor for Academic Diversity 3 years ago, and she's here full-time teaching at UC Davis School of Law now. She's won too many awards to mention, but they include awards from the American Bar Association and from UC Davis. And she's also a member of the American Law Institute, the foremost law reform institutional organization in the United States. So please welcome Professor Raquel Aldana. I'm looking forward to her remarks on citizenism and the shackles of borders.
Dean Johnson, thank you so much for such a kind introduction, and I want to commend you for setting up such a visionary racial justice speaker series. I've attended quite a few of them and have left feeling quite inspired, and so it's an honor for me to be presenting today. I also want to just say thank you to the amazing King Hall staff who worked so hard behind the scenes to organize the series, and thank all of you for coming today. I see that there's over 90 participants, and it's really a testament of how important these conversations are. So let me share my PowerPoint presentation. So I titled my talk, Citizenism and the Shackles of Borders. The reference to the shackles of borders visualizes the ways in which immigration law has always been punitive and has become increasingly so in recent decades. The focus of my talk will be on the subset of immigration law's punitive arm, the policing of immigrants both at and inside the US border, immigration detention practices, and the criminalization of immigration violations. The reference to citizenism, a term that according to the Oxford Dictionary has been around since the late 18th century to refer to a belief or advocacy of citizenship as the foundation of rights, situates borders as another tool of exclusion, which, not unlike prisons, deny rights to persons, the so-called alien, who are not considered part of the deserving. During this presentation, I show why any racial justice project must embrace the dismantling of citizenism as central to the transformation of the US into a more just nation. Photographer John Moore captured this image in 2018 during a ride-along with Customs and Border Protection, or CBP. It features a 2-year-old Honduran asylum seeker crying as her mother is searched and detained at the Texas border. The image quickly went viral on news media sources and on social media. The answer to the "I don't care, do you" jacket, at least on the issue of family separation, seemed to be a resounding yes. By this time, word had gotten around that the Trump administration had already separated around 2,000 children from their parents, including infants, pursuant to a zero-tolerance policy put in place in 2017 that criminalized all adult asylum seekers by charging them with illegal entry or re-entry crimes. There's a lot to update you just on the issue of the fate of these children, and I know that it must be on your minds, so let me just offer an update on this. The Trump child separation policy was cruel and a mess. Officially, the policy of separating children lasted only 4 months in 2018, but it never really fully stopped. In January 2020, the Southern Poverty Law Center reported that the official government number of children separated from their parents under the policy was 4,368. And as late as December 2020, a federal district court ruling revealed that 628 children separated under the Trump policy had yet to be reunited with their families. A more recent 2021 review done by the Biden administration found that more than 1,400 parents were ultimately deported without their children. But I actually want to our focus to rise to the mother, or rather what was likely her fate and the fate of others like her. We cannot see her face in this picture, but we should be forced to see her humanity. Before I try to construct the mother's likely fate, I want to explain a few important concepts of immigration law that will help us understand the structures, what I'm calling the shackles of borders, that have been built slowly over centuries to ensure that the same fate applies not just to this mother, but to tens of thousands like her. These same structures apply beyond those aliens who arrive at the border. Immigration law's reach, the so-called border spaces, have been expanded through law over time to occupy the workplace, the airports, your vehicle, the streets, and even your home. Moreover, these structures, which control the construction of legality and illegality, have a long arm's reach to long-term lawful permanent residents, and even citizens who associate or occupy spaces with the so-called aliens. So what are the structures? I'll briefly introduce key terms here and elaborate a bit more in subsequent slides. First, immigration law's exceptionalism. In the late 1800s, in a series of cases involving Chinese and Japanese immigrants, the US Supreme Court grounded the immigration power in the federal government extra-textually, meaning a power that is implied rather than expressly delegated by the US Constitution. To do so, the court relied on the war clause, on the composite of clauses that make up the exercise of foreign affairs, and then this idea of inherent powers and sovereignty. At around the same time, the US Supreme Court also declared that deportation is not punishment, even when so holding meant that 3 long-term Chinese residents who had been in the US respectively for 14, 16, and 19 years could not fight their deportation based on laws that had been applied to them retroactively and that require them to produce a white witness to vouch for their lawful presence in the United States. These rulings gave rise to what immigration scholars call the plenary power doctrine. Essentially, the doctrine declares that the US Bill of Rights either does not apply at all or applies very little against whatever immigration laws, policies, or practices the Congress or the executive chooses to adopt. Over time, immigration scholars speak of cracks or limits to this power. But as the Trump administration revealed, these cracks are no match to the metal strength that sustains the grip of the shackles of borders. In essence, this plenary power means that whereas, with few exceptions, the US Constitution confers most fundamental rights on the basis of personhood rather than citizenship, in the immigration context, citizenship and thus citizenism is a necessary precondition to rights. At the same time, immigration law has both borrowed shamelessly to function like criminal law, but because of the plenary power, there is both a symmetrical convergence between immigration and criminal law, but an asymmetrical divergence between the rights of immigrants and the rights of criminal defendants. Finally, in contrast to criminal law, and I think because of the plenary power's effects on issues of accountability, the immigration detention power has largely been privatized while leaving immigrants vulnerable to terrible abuses. So let me go back to the likely fate of our Honduran mother. You saw her being arrested by a CBP or Border Patrol officer for daring to cross the border to seek asylum, which by the way, for reasons I can explain during Q&A, was her only option to apply for asylum. And then she was criminalized and charged with illegal or improper entry into the United States. The data you see before you came from a report of the American Immigration Council titled Prosecuting People for Coming to the US, published in January 2020. The paragraph below it captures what I want to talk about. The number of individuals criminally prosecuted for entry-related offenses soared after 2007 as Operation Streamline expanded. I will come back to explain Operation Streamline. It matters a lot to the story, but for now, let me contextualize the data by discussing a bit how we came to popularize the criminalization of immigration violations in the US. The US has criminalized immigrants since as long as it created borders. However, it was not until the mid-1980s that we saw the exponential growth of immigration law's criminal regime. In the 1980s, Congress substantially expanded the categories of federal crimes, criminalizing non-citizens and at times those who associate with them. Moreover, the prosecution of immigration-related offenses exploded in the wake of 9/11. By 2005, immigration-related crimes represented the single largest group of federal prosecutions, outpacing even the prosecution of drug and weapon-related crimes. By 2020, prosecuting immigration crimes constituted over half of the federal criminal workload and eclipsed all other areas of criminal federal prosecutions. Indeed, non-citizens or the aliens have become the new face of federal prisons. Today, there are more than 60 federal crimes frequently used to prosecute immigrants. These include crimes like harboring, smuggling, aiding and abetting, and transporting the so-called illegal aliens, immigration fraud, identity theft. But the most commonly charged federal crime used against immigrants is the crime of entry or illegal entry. Why charge asylum seekers with illegal reentry crimes? The number one reason is the rhetoric of deterrence, which we also borrow from criminal law. If we treat her cruelly, meaning the Honduran mother, she and others will stop coming illegally to the US to seek asylum. The foil narrative is that if we treat her as a human being, it will encourage her illegal immigration and her irresponsible parenting. It is this narrative that too many are using to push President Biden to give up on comprehensive immigration reform and on any semblance of humanity at the border. So now back to Operation Streamline. This is an image inside a federal courthouse with a number of immigrants detained at the border who are now facing criminal illegal entry or reentry charges. Most entry-related prosecutions flow from a partnership between the Department of Justice and the Department of Homeland Security, DHS, and it's called Operation Streamline. DHS and DOJ initiated this initiative in Texas in 2005, and it is now in place in different forms in jurisdictions along the southwest border that include Arizona and Texas and California. The initiative was intended to deter future border crossers. In years past, the federal government would not have subjected these individuals to prosecution. But under the initiative, the government now charges first-time entrants for illegal entry, including those without any criminal history. It also conducts group prosecutions like you see here. And as many as 80 people, all at the same time, are subjected to a hearing that can last only a few hours, maybe less, all represented by a single lawyer. The so-called streamlined process, yes, a criminal trial, deprives immigrants of an individualized hearing and raises serious due process concerns. Individuals criminally prosecuted for interrelated offenses are entitled to a lawyer, yes, but this lawyer has to represent, as I suggested, sometimes hundreds in a rushed nature of a criminal trial, of a sham criminal trial. The attorneys might meet their clients for the first time in the courtroom that day, and they only have a few minutes in a public setting to discuss their case. Translation services are limited, particularly for those who speak languages other than Spanish. What must be especially traumatic for the Honduran mothers who likely met this fate is that federal judges can give her no real information about their children. In a recorded hearing leaked to the media that was subsequently played in a Democratic Now! Program, a judge is heard telling a different immigrant mother whose child had been taken away from her that she would be sent to a camp in Mexico under the so-called Remain in Mexico program, and that ultimately her child would be sent there to be reunited. And as we now know, that never happened in thousands of cases. Sorry. The Honduran mother in our picture arrived in the US pre-pandemic and pre-Trump's full-blown war on asylum seekers. It wasn't until 2019 that President Trump put in place the infamous metering or Remain in Mexico policies, and also entered into sham bilateral agreements, so-called safe third country agreements, with Central American nations, all in an effort to kill asylum protections for Central Americans. Then came pandemic, and well, Title 42 health-related restrictions completely sealed the coffin to asylum seekers at the border. Title 42 restrictions, by the way, remain in place at the border for all asylum seekers who are arriving. Since President Biden came to office, I have watched with interest and frustration how the media is going out of its way to blame the new administration for the new surge of Central Americans, especially Hondurans, on this myth that President Biden's soft and immigrant policies are to blame. And there's really two fallacies to this claim. Number one, immigrants arriving at the US-Mexico border in irregular status, including asylum seekers, have not ever had it easy when confronting the immigration power. And I'll spend a little bit of time explaining this. Second, immigrants arriving at the US-Mexico border in irregular status are all forced migrants who are choosing among at least two worst evils. Forced migration is a type of risk reduction strategy. As difficult as it might be, forced migration takes place once staying home has become the worst choice. And I'll also return to this point later in the presentation. On my first point, that there ain't ever been anything easy about crossing the US-Mexico border, let me go back to try to explain the likely fate of our Honduran mother. Remember that when we left her, she was in CBP custody. Where do you think she would be taken, minus her child? You guessed it, to an immigration detention center where she would stay and maybe transfer more than once, left her own without a lawyer to figure out how to get her daughter back and maybe fight to stay in the US with her. The CBP is not known for being kind. Indeed, the agency has been abusive and cruel for a very long time. The images you see before you are all recent reports documenting the types of abuses attributable to CBP. The titles speak of deplorable and prolonged conditions of confinement, including infamous hieleras or ice boxes. It also documents the killing of 120 immigrants since 2010, when the Deaths by Border Patrol Project began tracking the data. Few of these deaths have ever been investigated. And when they are, structures of impunity cloaked in doctrines like qualified immunity and Fourth Amendment free zones or mandatory detention laws breeds a culture that sustains the legacy of racism that has always fueled the agency. How many of you would be surprised, for example, to learn that the exclusionary remedy against Fourth Amendment violations does not generally apply at the border, and most certainly not to CBP? for two reasons. One, as heavily regulated spaces, borders are exceptional and privacy expectations are little to none, even if you're a US citizen. And two, if you're put in removal, the exclusionary remedy does not apply unless it is considered a quote unquote egregious violation, a doctrine that was established back in 1984 when the US Supreme Court decided INS versus Lopez Mendoza, which involved an immigration workplace raid. And due to the little to no expectations of privacy framework at the border, a finding of an egregious violation by CBP at the border is essentially unlikely. Despite CBP's terrible human rights record, it has not been as much part of the discourse on racial justice policing. Hashtag abolish CBP is a thing in the policing racial justice movement, but it is hardly popular. You're likely most familiar with hashtag abolish ICE, which stands for Immigration and Customs Enforcement, which is essentially the immigration enforcement entity that operates inside the US border. And I'll come back to that later in my talk. For now, let me share a little bit about the history of CBP and why we should care about ensuring that race-conscious policing reforms, whatever shape they take, apply also to CBP and to ICE. CBP has been around since 1924. If you listen to my colleague Jack Chin's compelling presentation on the history of anti-Asian racism in the US, you would know this was at the height of anti-Asian immigration restrictions. It was also when national immigration quota systems favored Northern and Western Europeans, and Mexicans became the new target of nativist immigration restrictions along the US-Mexico border. In the early 1900s, Mexicans were subjected to the same racist stereotypes as all non-white people in the US, yet Mexican immigrants were not subject to numerical restrictions or outright exclusion from the United States because, well, we needed their labor, especially in agriculture. And as a result, at the beginning of the 20th century, Mexicans did travel freely between the US and Mexico, allowing for social mobility and binational border communities. But that began to change with the passage of the Immigration Act of 1917, which doubled the head tax imposed on the visa fee, imposed the literacy test, some health restrictions, etc. The first list of restrictions on Mexican immigration began to grow during the 1920s, and the Immigration and Nationality Act of 1924 did not restrict Mexican immigration directly, but removed the statute of limitations on the deportation as a penalty for an illegal crosser. And therefore, the 1924 Act required also that all immigration people have to have a pass at any port of entry, and thereby creating for the first time the possibility that Mexicans could illegally enter the United States. This rapidly fueled nativist discourse of Mexican immigrants as criminals. Over time, the concept of the quote unquote illegal alien melded with racist stereotypes about Mexicans in general. Supporters of eugenics pushed for an end to Mexico's quota exemption, arguing that Mexicans were quote mongrels or inassimilable racial inferiors. It is against this backdrop that CBP was born. In fact, many officers in the CBP were originally recruited from organizations with a history of racial violence that included the KKK. This culture of racism within the CBP has persisted to today. Repeated reports have surfaced of agents using racial slurs, sexual comments, and other offensive language. Agents have maintained connections to the white supremacist movements, and they have also been used in paramilitary SWAT-style units and deployed to crack down on protests of police brutality against Black people, especially during Black Lives Matter. In fact, the image in this slide is of CBP officers deployed to police the BLM protest. Over time, the agency has grown exponentially to become more militarized. The first period of significant growth was in the late 1930s and early 1940s. This period coincided with the prioritization of immigration enforcement against Mexicans. A second significant period of expansion and militarization occurred in the 1980s when the agency's role changed also to intercept drugs at the border. The agency, for example, was issued high-powered military rifles under the rationale that drug enforcement was a high-risk undertaking. And of course, the September 11 terrorist attacks led to significant changes in the way that the US manages immigration enforcement, which also grew to include not only irregular immigration and illegal drugs, but also those who are considered terrorists. CBP is now under the Department of Homeland Security, and since the creation of DHS in 2002, CBP's budget has nearly tripled to the tune of almost 18 billion in fiscal year 2019. Much of this budget has been used for further border militarization, including border fencing, surveillance technology, etc. And this border militarization has had a harmful effect also on indigenous groups. For example, the Tohono O'odham Nation is bisected by a 62-mile section of the border. The O'odham people have frequent harassments and interrogations. They can't tell them apart from Mexicans. And therefore, they have an inability to travel to parts of their own territory. They are disrespected in their sacred landmarks and cemeteries, and of course, must endure the militarized construction without their consent of the border on their land. So violence and impunity within the border have been long systemic problems. This abuse comes in many forms, from killing to sexual assault. These abuses go unaddressed because disciplinary mechanisms within the agency are weak. And outside oversight agencies is grossly inadequate. A 2017 study by the Cato Institute found the Border Patrol agents were more likely to incur in misconduct and disciplinary infractions than all other federal enforcement agencies. For example, 6 times more likely than FBI agents. So I want to come back now to the topic of immigration detention. We lock up a lot of immigrants. Government data collected by the nonprofit group Detention Watch Networks puts the average daily population of detained immigrants, at least in 2019, at over 50,000, which amounts to over 500,000 immigrants detained annually. Immigrants in detention include both the documented and undocumented. We lock up survivors of torture, people seeking asylum, people who have been granted permanent status in the United States, who have US citizen children, people who have mental health issues, even babies and families. Immigration detention looks a lot like criminal incarceration, but it's also very different in 2 important respects. Immigration exceptionalism means that the same type of constitutional limitations that generally apply to criminal detention simply don't in immigration detention. Congress, for example, has legislated to make detention for certain groups mandatory without the possibility of bail or hearing. And much of immigration detention occurs in private-run facilities, about 81%, according to a recent study. And the private prison industry is big business in the United States. In 2019, Core Civic and Geo Group, 2 of the largest prison companies, had revenues of about $2 billion or $2.5 billion respectively. And of course, 20 to 30% of their revenues came from immigration facilities. This growth of the immigration carceral state tracks the explosion of prisons in the US more generally. As the US expanded prisons in the 1980s and 90s, the detention of immigrants, once a little known practice, began to take shape. In the early 1980s, those being detained were Cubans and Haitian refugees who were arriving in Florida's shores each year. And then, of course, immigration policy began to emulate the criminal justice system in the late 80s during the height of the war on drugs, when Congress amended the immigration laws to create mandatory detention for the first time. The 1990s brought on a paradigm shift in immigration policy, leading to the detention being the primary means of immigration enforcement. And in 1996, the US law enacted legislations that dramatically expanded the use of mandatory detention, including for long-term lawful permanent residents. And after September 11, immigration enforcement was turned into a national security issue. And what this meant was that the effective enforcement machinery that was going to be put in place to catch all of these people needed a robust immigration detention system. When ICE was created in 2003, it inherited an immigration detention system that held only about 20,000 people per day. Since then, immigration detention has grown to a sprawling network of more than 200 detention centers nationwide. Under the Obama administration, detention grew because of Central Americans, and it also was the resurgence of family detention. The Trump administration not only targeted all immigrants for deportation, but it expanded the use of private companies in the immigration detention system. The ICOU in a January 2020 study suggested that as large as 91% of immigrants were being housed in private detention centers. It's too early to tell what Biden is going to do about immigration detention. As a candidate, he promised to take a serious look at alternatives to detention. And he also quickly restored deportation priorities that deprioritize people without a criminal history, for example. But we also know that President Biden faces a lot of pressure to be tough on the thousands of Central Americans who are arriving, about 5,700 unaccompanied minors who arrived in January alone. And federal law dictates that most accompanied minors are supposed to be released within 72 hours. But the problem is that there is no space. So the Biden administration has caught flank for progressives from taking unaccompanied minor children to detention facilities and to other temporary locations such as convention centers. So the human toll of immigration detention are so many. In general, it's prolonged detention, but also no recourse to challenges of terrible conditions of detention. Let me briefly talk about prolonged immigration detention. It doesn't affect all immigrants. In fact, about 70% of immigrants in immigration detention are released within a month or less. But the relative short period that they are in immigration detention coincides with the growth in the number of expedited removals. And expedited removals means that people are removed by a single immigration officer without a hearing and without an opportunity to secure a lawyer or to present evidence. Yet, if you choose to fight your deportation, mandatory detention laws force you to have to fight sometimes under conditions of prolonged detention and potentially for years. And this is true especially because of the enormous backlog of immigration cases in the United States. As an example, decisions granting asylum or another type of relief today take twice as long as they used to. They're taking around 1,064 days on average. And asylum seekers, not unlike our Honduran mother, are mandatorily detained pending what is called a credible fear determination. The average detention is 27 days. But there's no guarantee, even though the law permits it, that they will necessarily be released after that time. They have to affirmatively request a formal bond hearing at an immigration court. And that is actually really hard to do without appointed counsel. So if prolonged detention times last really long, maybe 6 months, there could be some relief. Very briefly, I want to mention that in 2003, the Supreme Court decided a case called Demore versus Kim. It actually upheld the constitutionality of mandatory detention and removal proceedings under the assumption that immigrants are detained for quote unquote a very limited time. But quite frankly, the data was manipulated, or at least the court chose to manipulate it by suggesting that the length of time that all immigrants are in detention should be taken into account. And that was calculated at around 47 days. But as I just told you, if you choose to fight your detention could be for years. And so the way of calculating the length of time that immigrants spend in detention depends on your willingness to give up on your immigration claims. Very briefly on the conditions of detention, the types of allegations are really deeply problematic. I put up a report that was recently published by the University of Texas about one particular center that is privately owned that detains asylum seekers, only women up to 512. And this particular detention center is known for sexual abuse. I'll read briefly a paragraph from that report. The facility has been plagued by sexual abuse of detained women. In 2010, a core civic employee pled guilty to sexually abusing several women as he transported them out of the facility. In 2017, the FBI opened a civil rights investigation after a detained woman, Laura Monterrosa, reported sexual abuse by a guard. The facility responded to the accusations by placing Laura in solitary confinement for 60 hours and threatening to keep her there indefinitely if she didn't retract her accusations. Despite the trauma she suffered from the entire experience and the resulting suicide attempt, Laura did not receive meaningful medical or mental health care. So in my earlier comments, I mentioned that unlike CBP, the racial justice movement around policing has taken greater notice of ICE. Part of the explanation is that ICE functions within the border. It has followed similar patterns of exponential growth in militarization, as I described with respect to CBP. But because it raids workplaces, people's homes, and very public forms of arrest, the effect of ICE enforcement is more visible to us. It's harder to ignore the plight of immigrants who live among us. But I want to add a different dimension to the story related to inside the border enforcement, which is illustrated by the child who is holding up the sign that reads, police plus ICE equal insecure. Inside the border enforcement is also troubling because it is nearly impossible to separate it from traditional policing. Both a tremendous growth in technology, as illustrated by some of the images, and the collaboration between ICE and police have really blurred the line between traditional policing and immigration enforcement inside the border. And this is also eroding Fourth Amendment rights, not just for immigrants, but for all of US citizens. Since 1994, the then INS, now ICE, established what is known as Law Enforcement Support Center, which is a clearinghouse that fields around the clock inquiries from law enforcement agencies concerning the immigration status of individuals under investigation. And from 1996 to 2005, the number went up exponentially from 4,000 to about 1.5 million. This trend is indicative of what has been known as the force multiplier that has resulted when immigration laws are being enforced by local police, particularly after 9/11. Local police are asking people for their immigration status during traffic stops, etc. Some of this immigration enforcement by local police is encouraged by Congress. I'm going to skip the specifics of that because of time, but there are things like 287G agreements that I'm happy to talk about during Q&A. But I also want you to know that much of local police enforcement is occurring without this formal memorandum of understanding or any federal funding. And the ability of the police to do this work is greatly enhanced by technology and data sharing. In 2013, for example, programs like Secure Communities and the National Crime Information Center Information Database, or NCIC, has essentially become the most effective means of detection of immigration violators across the US. Professor Anil Kalhan called this the rise of automated immigration policing. And I'll spare you the specifics because of time, but essentially it allows police to sit in their police cars and check for people's immigration status while they're doing a routine traffic stop. And they can arrest you. And then once you're arrested, your fingerprints can be run through federal databases that now contain immigration information. That's how they turn you over to the immigration federal agencies. I'll speed it up here. This is trying to show you what has been the effect of this deportation machinery. If you look at the numbers and how they shifted between the Clinton administration and George W. Bush and Barack Obama, you see the enormous transformation in our ability to deport people in the United States. It's become a very effective machinery. And this is how Obama got the deporter-in-chief label, and he quite deserved it. When you look at Trump's numbers, that's only 2 years versus 8 for Obama. But even if you take into account all of President Trump's 8 years, he's not going to be able to outdo those numbers. I do want to say that this machinery of deportation functions in a highly racialized way. So I just want to quickly show you 2018 data. And you see that the top 9 countries are from Latin America, and the last one is from India. We are deporting brown people. I could say a lot more about this, but because of time, I will try to answer any questions you may have during question and answer. So I'm almost to the end. I did want to speak about a final policing story that also likely contributed, if not directly pushed our Honduran mother from her home with her 2-year-old child. It's an invisible story that has so many ill effects that are being driven by our domestic policing practices on nations like Honduras, who are now plagued not only with gangs, but with narco traffickers who have captured the state and turned it into a corrupt nation that is unwilling or unable to help its citizens be able to live dignified lives. Honduras is one of the most violent countries in the world. In 2019, it had a homicide rate of 44.7 per 100,000 people. There's probably multiple explanations for this, but at least two are connected to our domestic policing policies. One is the mass deportation of criminal aliens, so-called criminal aliens and gang members, and also the US war on drugs. Since the 1990s, we have had a tough on the criminal alien stance. We deported between 1996 and 2015, 5.4 million people with a felony conviction. 46,000 of them between 1998 and 2005 were sent to the Northern Triangle region. This expanded US-bred gang and criminal culture across the region. A 2006 Congressional Research Service, which is the research arm of Congress, had this to say about the transnational gang problem in Central America. The major gangs operating in Central America with ties to the United States are the 18th Street Gang, also known as M18, and its main rival, the Mara Salvatrucha, MS-13. The 18th Street Gang was formed in the 1960s by Mexican youth who were not accepted into Hispanic gangs in the rampant section of LA. It was the first Hispanic gang to accept members from all races and to recruit members from other states. MS-13 was created during the 1980s by Salvadorans in Los Angeles who fled the country's civil war. The expansion of MS-13 and 18th Street gangs in Central America accelerated after the US began deporting illegal immigrants. Honduras also is now one of the places where a key transit country for drug trafficking, according to a US State Department report in 2018. The war on drugs has spread throughout Latin America since it began in the US in the 1970s. The US has spent trillions of dollars attempting to dismantle drugs in Latin America. It has not worked. I'll spare you the specifics. Basically, a lot of scholars studying this phenomena call it the cockroach phenomena, because what happens is they go into Peru, Mexico, Colombia, spend trillions of dollars, and the drug lords simply go to places that are vulnerable. That's how they ended up in the Northern Triangle. That's how they ended up in Honduras. And when the war on drugs arrived in Honduras, crime related to drug trafficking soared. This is why people are fleeing the region. And you may have heard that the levels of corruption that this has caused are so profound that even the president of Honduras, Juan Orlando Hernandez, has recently been charged by a US prosecutor, or accused rather, in federal court for taking bribes so that he can stay in power. So I know I'm out of time, so I'm going to try to be very brief here. Let me close by just posing an important question. What would a due process revolution that dismantles how policing against immigrants is done in the US look like? Two things. One is that it has to, in my opinion, be grounded in legal and constitutional law. I wrote a piece recently with a wonderful co-author who's a historian, Tom O'Donnell, to look at the Warren Court due process revolution. Our piece was looking at why were immigrants left out. And I can tell you that it wasn't because immigrants were being treated any kinder. This was an especially bellic time. It's the time of the Vietnam War, it's the time of the Cold War. There was plenty of opportunity for the Warren Court to imagine bold ways of protecting immigrants, but everything that it did during that time was quite meek. So this is what leads us to what we're experiencing today. We haven't had a due process revolution, and I don't have a lot of faith in our current Supreme Court to lead us there, which is why my second point, I think transformation of rights has to be cultural and it has to be political, and it has to take place locally and nationally. We, the citizens with political power, have to recognize that fundamental rights cannot be defined by citizenship or even by borders. This concept may seem radical, but I have faith. And this is where I will stop, and I look forward to taking your questions.
Okay, great. So we'll as you said, get started here with our Q&A. And we have a question about racism from a student who says that you've been arguing, and quite persuasively, that racism is baked into the US immigration laws and their enforcement. And they're wondering, why do you think this is?
Well, immigration law, in my opinion, is simply another tool that has replaced laws. I mean, we had, I'm not comparing, so I want to be careful here, but we had slavery as a tool of oppression that was based on a very racist project. We had Reconstruction, the period of Jim Crow laws that maintained this idea of second-class status in a very racialized way. And in my opinion, borders and immigration law has simply just been another tool that is no different from these other structures. And if you actually trace the history of immigration law, you will see that it has been profoundly racialized, and it has been used as tools for oppression that are connected, directly connected also to an economic exploitation project. We need the vulnerable workers, the exploitable workers, in order to make our economy work.
Okay. A question from Mark, who says, the stats about removal are interesting, especially over the last 3 or 4 administrations. Has the ratio of total removals compared to total entries changed?
That's a really good question. And I don't have, I always am cautious when I'm responding to data. I don't have specific data to share with you, but I can tell you, for example, that people do not know that I think it was 2017 when the net immigration gain from Mexico was 0. That meant that the number of people coming in and also leaving, whether forcibly or whether voluntarily, was a net 0. And I think that that never becomes a part of the narrative in the media, right? Why is this happening? I think part of it is because Mexico is the 5th largest economy in the world. No one ever talks about that. We see our brazen, our brothers and sisters in the South as a developing nation, as an emerging nation, rather than as an economic partner, which is what we ought to be embracing. And when we do that, right, we tend to create narratives that are simply not based on real data. The truth is, at least Mexican migration has been significantly reduced in recent years. We have seen a surge in Central American immigration. And so so one of my response would be that the data would probably differ depending on the group that you're studying.
Okay. Comment and question from Natalia, who says, thank you, Dr. Aldana, for your presentation. The Trump administration refused to facilitate abortion for pregnant teens in custody who are in detention centers and blocked migrants in US custody from having abortions at their own expense. How do you see the future in terms of access to reproductive health care in the Office of Refugee Resettlement?
It's a really great question and a really hard one to answer because it's also obviously happening within a broader conversation around reproductive rights outside of incarcerated communities. I had a wonderful undergraduate student. I taught a class on these issues, and a phenomenal undergraduate student wrote a paper precisely examining this question. Do incarcerated people have a right to a government-paid abortion? I'm not an expert on this. My recollection from reading the paper several years ago is that, a right to paid abortions may not apply either to incarcerated women, who are US citizens. And so I think the conversation can't be completely detached, right? What's happening in the immigration setting can't be completely detached from a much broader conversation about attacks on reproductive rights more broadly in the United States. And so I think, it is how it manifests itself in the immigration context is that it's less visible. It's also harder to achieve any level of justice because of what I've been describing. Many of these immigration centers are private, which allows them to control information. We may not really understand what's happening behind these detention facilities and what is possible. So the other, kind of comment that I want to make is that the privatization of immigration detention has also been deeply problematic in terms of these kinds of rights, not just reproductive rights, but access to any type of mental health or even basic medical services for immigrant communities in detention.
A question from Carrie, who writes to first say that your presentation, Professor Aldana, has been excellent and thorough, and wanted to thank you for that. And then goes on to say, what are your thoughts on the potential or lack thereof of constitutional equal protection as a means to address racism in immigration law?
Well, I do think it's time to dismantle the plenary power doctrine. And there have been instances of hope throughout the history of US immigration law. But the problem is that when you start to see, like you see scholars starting to write the death of plenary power, these titles that are really hopeful, and then something happens, because that's the thing, the vulnerability of immigrant communities is pronounced significantly by their lack of political rights, and also the cultural insistence that rights should be preserved for US citizens. That's what we have to dismantle. And so what happens, right, is that they are really vulnerable to political moments that can undermine what has taken decades to build, right? So you start to fight. There are these grassroots movement. It takes them forever to identify the right case. They think very strategically about how do we argue this case to win a small victory in the courts. And then they start building these small judicial victories only to have it be completely toppled down by these important political moments. What are these moments? Usually war. War is a special time to just dismantle everything you've tried to work for in the last 4 years. And then elections like the election of President Trump, which was clearly built on a xenophobic, anti-immigrant agenda. In the last 4 years, he passed more than 400 executive immigration orders that completely altered what had taken decades to achieve. And so those political vulnerabilities, I think, which is why I said we need both. We need the cultural transformation, the political transformation, but we also need the radical transformation of our constitutional law in this area.
Okay. We have a question that surrounds some of the tragedy really that we see at the border. And that is that I understand, this is the question, I understand that deaths occur regularly along the US-Mexico border as migrants travel through deserts and mountains. Why do so few Americans seem to know or even care about these deaths?
It's an excellent question. I think, so I actually talked to my sister, who keeps me honest, because she knows that I'm very, very emotional and committed to immigrant rights. She is herself an immigrant. She came to the US at age 3. I am myself an immigrant. But maybe because she was so young, she does have a slightly different perspective. And to her, citizenship is central to rights. And she always says to me, what you're arguing is really hard for Americans. And she uses the word American. And I always remind her, no, I don't like the word American. It's US citizen, because America, there's an entire continent that's called the Americas. But so you can see, I have a much more of a global citizenship perspective, an international human rights perspective as a former human rights lawyer. And I think it's very difficult sometimes to, because my sister is not conservative, she's progressive, but it's really difficult even for people who are brown, even for people who are progressive, to start to imagine, right, or to equate borders to, say, mass incarceration, or to equate borders to the horrible historical period of slavery, right? To imagine that borders are just as oppressive, just as racist. I think it's hard for people to make that connection, even well-intended people. And so when we construct this idea that rights should belong to citizens, it's a zero-sum game. It's the idea that we have too many problems in the US to worry about the rest of the world. And what I try to argue in my talk is that when you do that, you do it at your own peril. Because even if you're only self-interested, when you deny rights to others, it starts to affect your own rights. So there's an erosion of rights that is beyond how it affects the other. But more importantly, right, I've tried to argue in my talk that personhood should be driving our conception of rights and not citizenship and not geographic location. Because again, even if we're only self-interested, our policies, because we are such a powerful economy, such a powerful and influential nation in the world, our policies in the US affect other countries, and the effects on other countries come back to bite us, as we have seen with so many Central American arrivals recently.
Okay. I had a follow-up question come in from Carrie, who said, if I heard correctly, in addition to political and cultural change, I think you referenced open borders. If so, what are your thoughts on open versus the no borders framework that is emerging in scholarly circles?
It's an excellent question. You know, I'm not arguing for the complete deregulation of borders, right? Like a complete free flow of people. Why? Because, you know, I'm a lawyer, I still believe in laws, and I still believe that laws can be just and fair. And I do think that sometimes laws serve a compelling state interest. So no, I don't think that terrorists, if there are true terrorists or dangerous people, let me stop using the word terrorist, let me just say dangerous people, should be allowed to come into the United States. Let me use pandemic as an example. Is migration, right, in some ways directed to the spread of pandemic? I don't think we can deny that it was travel from across, you know, different countries that helped the spread of pandemic. I do think there are reasons why governments have to regulate borders that are legitimate, that are compelling reasons, but they're very narrow. We have figured out how to regulate the transfer of goods and services across borders and trade. Why? Because we care about money. We have left out the people, the workers, right? And I feel like it's time for us to move to an EU-like system of migration. It's not a free flow, it's not free borders. It is a system in which open borders functions as the default. And the regulation of people can only occur when there is a compelling state interest. And so that is my vision. And I do understand that for some of you who might even be more progressive than me, doesn't go far along or enough into your thinking. And I would love to have more conversations with you about that. Maybe I'll say one more thing. It's not just the compelling state interest, but I also I'm having a hard time intellectually understanding when we get rid of borders, right? What replaces the nation state? We still locate, right, the nation state as the bearer of the responsible for the distribution of rights and the distribution of resources. And it's very difficult for me to imagine. It doesn't mean that it can't happen, but I think we have to be very creative, right? What happens when we get rid of nation states? How do we engage in that project of distributional justice and distributional resources? Very interesting questions. I don't have the answers.
Well, thank you for your answers that you have given. And I will say that we are at time for our Q&A, and I wanted to thank everyone for your thoughtful comments and questions that you did submit.
Thank you.
Thank you all for being here today. And thanks, Professor Aldana, for your thoughts and provocative insights. Take care all.